So you want to reduce your sentence or modify your sentence. Maybe some conditions aren't appropriate anymore. And I want to talk to you about how you can do that. The first consideration is you've got to do this within 60 days. If you wait longer than 60 days, the rule on this 3.800 subsection C says you're out of luck. So the court only has a short 2-month window to even consider a modification. Keep that in mind. Second, let's go through a couple examples of some real life stories of how people got their sentence modified or didn't get their sentence modified. And we're going to start with State v. Howell. Miss Howell was sentenced here in Orange County to 6 months jail and 4 years of probation. She got that through a plea deal. The state agreed to reduce some charges and not take her to trial where she could get prison. Well, within 60 days, she decides she doesn't like this jail term and doesn't like the 4 years of probation they're facing her, and she goes back to court. The judge actually agrees with Miss Howell and knocks the jail down to 90 days and knocks the probation down to 18 months probation from 48 months. The state goes ballistic. They file an appeal, and on appeal, the state won. Let me tell you why the state won. Because your plea agreement is like a contract with the state. And what that contract says is that, look, we're not going to take you to trial. We're not going to send you to prison if you lose that trial, and you're going to get 6 months jail and 48 months probation in exchange for that agreement. But you can't come back later and say, well, gee, I want something even less. The state throws up their hands and says, well, then I want a trial. And they can get the trial. So you can actually withdraw your plea within the 60 days. But in the appellate court in State v. Howell said, oh no, you cannot strike down a plea deal like that. The appellate court reinstated Miss Howell's 6 months jail and 48 months probation. So that's one example of what you cannot do. Another way that you might want to ask for a modification, the example I give is State v. Petre. And in State v. Petre, Petre was convicted of a sex offense that requires him to wear an ankle bracelet, a GPS monitor. He had a 9-year probation sentence with the GPS monitor, and about a year into it, he figured out what I and everybody else already knows who's involved in the criminal justice system. These GPS monitors are absolutely impossible to live with. You try to work indoors and your ankle is going off and beeping and embarrassingly alerting everybody that you have an ankle monitor. So what ends up happening is Petre goes to court and says, I'm fine with the 9 years probation. Judge, will you just remove this ankle monitor? The judge agrees, removes the ankle monitor. State appeals, and the state wins on appeal. The appellate court said you got to put the ankle monitor back on because the ankle monitor is a mandatory part of that particular sex offense's probationary requirements. You cannot change the requirements that the legislator has laid down for somebody on sex offender probation or any other type of probation. There are certain things that the judge cannot tinker with. And you can get reductions under certain circumstances, like if you were found guilty at trial and the trial judge sentenced you, you can go back to the trial judge within 60 days and ask for something less. There's nothing wrong with that. There's no plea agreement to disturb. There's no contract to disturb. Yeah, you can go back. Bottom line, got to get a local attorney that knows that judge and has filed a modification before. If you find somebody that's done it before, especially in front of that judge, no problem. They'll be able to navigate these murky waters. Good luck.